please.
I'd like to have a motion on notice. My Lord, we have a motion on notice. Dated the 18th day of May 2022.
Yes. Yes.
Extension of time, a harmless motion, my Lord. If the other side is not opposing, we move it down.
Yes.
My Lord, we are not opposing.
Court application granted.
My Lord, we have also filed our final
Time is hereby enlarged with us. They already filed and served.
The Lord, we filed our final written address. It is dated the 30th of May. 31st of May, sorry, 2022. And we are praying that, my Lord, and
All right,
filed on the first one. The Lord, we filed our final written address. We don't want to waste the time of the court. It is dated the 31st day of May. And filed on the 1st of
Mr. Abdulaziz, I cannot hear what you are submitting.
You know, there's actually noise. I don't know where it's coming from. I said we filed our. Hello?
Yes.
We filed our final written address. It is dated the 31st day of May 2022, and filed on the 1st of. It is dated the 31st and filed on the 1st of June. You know, we are applying that it be deemed as properly filed, so that if the defendant intends to file the reply points of law, then I don't know. But if not, we are ready to adopt all the processes. Now,
Mrs. Umaula, are you willing to file a reply? Mrs. Umar, do you wish to file a reply?
My Lord.
Sorry, I didn't hear that.
Adopt. No, my Lord, we are ready to adopt. We are ready to adopt, my Lord.
Okay, you can proceed, please.
Thank you, my Lord.
Proceed.
My Lord, we filed the defendant's final written address.
Yes.
Dated the 13th day of April, 2022.
Yes.
We adopt all the arguments and submissions.
Yes.
As our position in the matter.
Yes.
And we humbly urge the Honorable Court, my Lord.
Yes.
To refuse to dismiss the case in its entirety.
Yes, Mr. Abdulaziz. Thank you, Mr. Abdulaziz.
Thank you, madam.
You know, our final written address, the claimant's final written address, dated the 21st day of June, and it was filed on the 1st of June. The Lord, we filed it as our final submission.
What date did you say you filed it? Mr. Abdulaziz, what date
June.
did you file it?
1st of June, the Lord. 1st of
Okay.
June. Yes, Lord,
Yes.
2022. Yes, Lord, and we adopt it as our final submissions in this matter, which is a succinct analysis of the part of the case and the claimant part of the court honorable court. And we urge my Lord to grant the plaintiff's claim in its entirety. We so submit, Lord. We're most grateful.
Thank you. Court cases adjourned to the 3rd of October 2022 for judgment. Yes, thank you. The next case, please.
Case number 2, NICS/KD/2020/2020 between Mr. Adibido Checho Oluwasegun and 1 Kaduna Polytechnic, 2 the Governing Council Kaduna Polytechnic, 3 the Rector Kaduna Polytechnic, 4 the Registrar Kaduna Polytechnic, and 5 the Chairman Senior Staff Disciplinary Committee Kaduna Polytechnic. My Lord, the claimant is present. Defendant absent.
Yes, appearances, please.
With profound respect, my Lord. Adebola Funsho Fashola is my name.
Is the claimant in court, please?
Yes, my Lord.
Yes, AF Fashola for the claimant.
For the claimant, my Lord.
Yes, we received a letter from the Defense Counsel, Mr. Ishak, that he wants his adoption to be deemed adopted.
God pleases, we have seen a copy of the letter, my Lord.
Yes, in response, sir. Mr. Fashola.
Yes, my Lord.
Yes, you can move your own.
As God pleases, my Lord. My Lord, the claimant's final written address is dated the 25th day of March, 2022, my Lord. It was filed on the same date. My Lord, we equally file additional authorities.
You filed your written address when?
It was filed. It was filed on the 25th day of March 2022, my Lord.
Yes.
Yes, my Lord. We equally file additional authorities, my Lord.
Yes.
Same is dated the 19th of May 2022, my Lord.
Yes.
Equally filed on the same date, 19th May 2022, my Lord.
Yes.
My Lord, we most humbly adopt all our submission and the legal arguments contained in our processes, my Lord.
Yes.
We most humbly urge, my Lord, to grant all the claims of the claimants, my Lord, and to also dismiss the counterclaim of the defendants, my Lord.
Thank you.
Most grateful, my Lord.
The defendants filed a reply to your counsel claim. Sorry, to your address.
To our additional authorities.
I said, did the defendants file a reply to your address?
Yes, my Lord. They filed a reply. The reply is dated. They filed a reply, my Lord.
Okay, thank you.
Thank you, my Lord.
Court case is adjourned to the 4th of October 2022 for judgment.
God bless my Lord. Thank you, my Lord.
Yes, the next case, please.
Case number 3, NICN/KD/31/2021 between Mr. Bakile Nandi and Dia Fatimileyin and Co. My Lord, parties absent.
I'm here.
Yeah,
I'm
party is
available.
absent. Are you a party in the case?
Yes, Bamideleni.
Okay, claimant present.
Bamideleni.
Yes, claimant present. Defendant absent. Appearances, please.
May it please, my Lord. My name is G.A. Solomon.
Yes.
My humble appearance is for the claimant.
Thank you. Yes, defense.
May it please, my Lord. Masood Alabelewe is my name, my Lord. I humbly announce appearance for the defendant.
Yes, sirs.
My Lord, the matter is for...
Yeah, the matter is for adoption, Mr. Alabelewe.
Yes, my Lord. We filed on behalf of the defendant a final written address dated 4th, but filed on the 5th day of April 2022, my Lord.
Yes.
We, subject to your Lordship's permission, we adopt the said address as our argument and contentions in urging, my Lord, not to grant the reliefs of the claimant, my Lord, especially the reliefs for damages. My Lord, by way of adumbration.
Yes.
My Lord, by way of adumbration, we submit most humbly that damages is awarded to compensate for the wrongful act of a defendant. My Lord, the failure of the defendant in this matter to pay salary has been explained. My Lord, it is not a wrongful act. In fact, the claimant was not singled out for non-payment of salary. My Lord, there's no malice in the non-payment of salary. It was due to economic indices. Furthermore, my Lord, here is a claimant who resigned voluntarily from the services of the defendant and thanked the organization profusely for giving him the opportunity to serve.
Mr. Alabelewe, you should remember that I'm still putting down notes, even though online. Sir?
Yes, my Lord.
Yes, sir.
I'm
You
sorry,
said
my Lord.
Furthermore,
my Lord, we have shown from the evidence of the defendant himself that he resigned voluntarily from the evidence from the employment of the defendant.
Yes.
And in very glowing and very, very kind languages, he extolled the virtues of the defendant and appreciated the defendant for the opportunities given to him to serve. It therefore shows, my Lord, that there was no malice. There was no sort of love lost between the claimant and the defendant at the time he left the services of the defendant. And there was nothing to show, my Lord, that the failure of the defendant to pay him the salaries for the period in contention was malicious.
Yes.
We therefore urge my Lord not to award damages because there's nothing to indemnify the defendant for. No wrongful act has been committed here. It's a normal thing for employer not to be able to pay salaries because of downturn or economic indices. My Lord, that's our humble prayer. We're most grateful.
Yeah, just a minute. Yeah, just a minute. Yes, Mr. Solomon.
Thank you, my lord. My lord, the claimant had equally filed his final written address dated 25th day of April, 2022. And it was filed on the same date.
What date?
The 25th day of April, 2022.
Yes.
Although we adopt the same exact written address as a final written argument in this case, and in urging my lord to grant the reliefs as claimed by the claimant.
Yes.
My lord, we quickly respond to the defendant's argument that the claimant was not singled out.
Sorry, did you file a reply?
My lord, we didn't file a reply because we are not entitled to file one, my lord.
Why are you not entitled?
My lord, because we are the claimant here. They filed their written address first.
Oh, sorry about that. It's the defendant that ought to file the reply. Yeah, so are you adumbrating?
Yes, my lord, I am adumbrating.
Yeah, thank you.
Thank you, my lord. My lord, our submission is simple. The defendant's sole witness,
Yes.
admitted under cross-examination,
Yes.
was paid his outstanding salaries and allowances.
That the claimant was paid his outstanding salaries.
My lord, the defendant's sole witness,
Yes.
admitted under cross-examination,
Yes.
that he was privy to the letter of demand that was written to the defendant to pay the outstanding salaries and allowances.
Yes.
My lord, beside the fact that he admitted being privy to the said letter of demand,
Yes.
equally admitted under cross-examination that he was paid his outstanding salaries and allowances.
Yes.
My lord, this goes to prove that the claimant was actually singled out.
Yes.
Since the signatory to the said letter of demand were paid the outstanding salaries and allowances, it's only the claimant that has not been paid.
Because he was no longer in the employment of the company.
Yes.
My lord, furthermore, payment of damages.
Yes.
It's an event that follows cost.
Yes.
Commission that the claimant has not proved that he's been singled out is of no moment here, my lord.
Yes.
And what the claimant is asking for is general damages.
Yes.
Which is at the discretion of my lord, as my lord will deem fit.
Thank you.
As my lord will deem fit to award consequent upon the act of the defendant that has brought injury to the claimant.
Yes.
We've cited cases of which we don't want to bother my lord. They are all contained in our final written address.
Yes.
We simply ought to enter judgment in favor of the claimant. We are most grateful, my lord.
Court case is adjourned to the 3rd of October, 2022 for judgment.
As a court,
As the court pleases.
we are most grateful.
Yes, thank you. Yes, the next case.
Case number 4, NICN/KD/05/2017 between Edilegu E, NBC and 39 others, and Peugeot Automobile Nigeria Limited. My lord, the claimants are present. Defendants are.
Claimants present.
Yes, my lord.
Defendants absent.
Yes, my lord.
Yes, appearances, please.
With due respect, my lord. My name is CT Agu. CT initial Agu.
Yes.
And with me is Eyitope Adeowu.
Temitope or Eyitope?
Eyitope.
What's the last name?
Adeowu.
Sorry, I didn't hear that.
Adeowu.
Yes.
We appear for the claimant.
Yes.
Most respectfully, my lord, LJ Lagam. I appear with MC Oha Eju.
Can you spell the last name, please?
OHA
Yes.
UGWO.
OHE.
OHA
Okay.
EJI
Yes.
UGWO.
Okay. For
We
the
appear-
defendants. Judgment. The claimants were employed at various times and at different capacities by the defendant. The case of the claimants, briefly stated, is that they were unlawfully locked out of the premises of the defendant on the 25th of November 2010 without having their appointment terminated. According to the claimants, all efforts made to either continue their duties or have their appointment terminated by the defendants as provided by the terms of their employment proved abortive. The claimants alleged that they continued to report for work from December 2010 when they received their salaries until the present suit was instituted. They further alleged that they had suffered untold hardship from being locked out by the defendant. Being aggrieved by the alleged actions of the defendant, the claimants commenced the instant action by complaint and statement of facts filed on the 14th of February 2010, but later amended on the 13th of February 2018 by leave of court, and by the operative further amended complaint and statement of facts also filed by the leave of court on the 11th of February 2019. The claimants claimed against the defendants the reliefs set out as follows. To save the time of the court, the reliefs are stated, 8 of them on the face of the judgment. Expectedly, the defendants contested the claimant's claim by filing a statement of defense subjoined by a counterclaim. The operative further amended statement of defense was deemed filed on the 5th of July 2021. The gist of the defense advanced by the defendants to the claimant's claim is that due to economic and financial challenges, the defendant was forced to downsize its workforce by terminating the appointment of some of its workers, inclusive of the claimants. That, sequel to the termination of the claimant's appointment, they were paid their salaries for November 2010 and the requisite 1 month salary in lieu of notice. That the claimants, through their union, Steel and Engineering Workers Union of Nigeria, SEWUN, instituted an action against the defendants at the Industrial Arbitration Panel, IAP, for reinstatement of the members whose appointments were terminated and for other reliefs. That the matter was finally settled on appeal at the National Industrial Court, Abuja, and consequently, the claimants are thereby stopped from litigating on the subject matter. The defendants contend that the claimant's case is frivolous and by way of counterclaim sought the relief set out as follows. 1, special damages in the sum of 8,075,000 naira only, being cost paid and incurred and directly resulting from the defense of the claimant's suit. And 2, the cost of the suit. The claimants further replied to the defendant's further amended statement, and further defense to counterclaim was filed on the 18th of June 2019. Whilst the defendant's counterclaims reply to the claimant's further defense to counterclaim was filed on the 26th of June 2019. The matter proceeded to trial. In support of the case, the first and second claimants, Hehilebu Undubisi, CW1, and Umar Aminu Bajoga, CW2, testified in person and on behalf of other claimants. They both adopted their statements of oath as their respective evidence in chief and further tendered 78 sets of documents in evidence as exhibits. They were duly cross-examined by the defendant's learned counsel. The defendant in turn fielded 4 witnesses. One, O. Okoli, a member of staff of Access Bank, was subpoenaed and testified as DW1. The second and third witnesses, DW2 and DW3, namely Abubakar Iman and Stephen Elue, were also subpoenaed as members of staff of Keystone Bank and First City Monument Bank. The witnesses tendered a total of 40 documents on the basis of the subpoena served on their respective banks. An employee of the defendant, one Yemi Oyelola, testified as DW4. He also adopted his statement on oath and further tendered in evidence a total of 66 documents in evidence in further support of the defendant's case. He was equally subjected to cross-examination by the claimant's learned counsel. Upon conclusion of plenary trial, parties filed and exchanged their written final addresses as prescribed by the rules of this court. In the final address filed on behalf of the defendant on the 23rd of December 2021, L.J. Lagan, Esquire of Counsel, identified 3 issues for determination in the suit. That is, 1, whether in the light of the trace dispute in IAP/8B/5839/11 on appeal as suit number NICN ABJ/106/2011 between Peugeot Automobile Nigeria Limited versus Steel and Engineering Workers Union of Nigeria, wherein consent judgment was entered on April 9, 2014. This court has the jurisdiction to entertain the suit and or whether this suit is not statute barred. 2, whether on the preponderance of evidence, the claimants have proved that the termination of the employment by the defendants on November 30, 2010 was unlawful, null and void, such that would entitle them the grant of their claims as contained in the further amended statement of fact dated and filed in January 2019. 3, whether in the light of the evidence laid before the court, the defendant's counterclaimant has not proved its counterclaim to be entitled to judgment in respective of the counterclaim. I shall state that on the 5th of April 2022, the date of adoption of written addresses, the names of the claimants initially listed as the 32nd, 34th, 36th, and 39th claimants, namely Aku O. Clement, Jonathan Ayemoba, Ibrahim Yaro, and Rufus Oladele, was struck out. This was based on an oral application made by the learned claimants counsel for the striking out of their names on the ground that the claimants had settled with the defendants. The written final address of the claimants was filed on the 28th of January 2022 by Chuks T. Agu, Esquire of Counsel, wherein 3 issues were also distilled as having a reason for determination in the suit, namely 1, whether with reference to the terms of settlement in appeal number NICN/ABJ/106/2011 between Peugeot Automobile Nigeria Limited and Steel and Engineering Works Union, which led to the consent judgment between the 2 parties therein on the 9th of April 2014, this court lacked jurisdiction to entertain the suit and or whether the suit is statute barred. 2, whether from the total pleadings and evidence adduced before the court by the claimants, the locking out of the claimants from the defendant's factory and the claimants officially working, the claimant's official working place on 25th of November 2010 amounts to termination of claimant's employment in accordance to the terms of contracts of service between the claimants and the defendants. Whether the entire evidence before this court shows the defendant is entitled to the defendant's counterclaim before the court. The defendants further filed a reply on points of law on the 14th of February 2022 in response to the claimant's final address. Now, in order to streamline the issues that are germane for determination in the suit, I had undertaken a painstaking examination, assessment, and evaluation of the pleadings of the parties and the evidence adduced on either side in order to distill the facts that appear not to be in dispute or was clearly established. This task seems not too difficult, considering that the evidence adduced by either side to support their respective pleadings is largely documentary in nature. The focus of the court is directed principally at the documents tendered by the parties as the yardstick to assess the oral evidence adduced by the respective witnesses. This course is in consonance with the established legal proposition that documentary evidence, being the best evidence, is the yardstick or anchor by which to assess the veracity or credibility of oral testimony, and that extrinsic evidence cannot be admitted to contradict it, add, or vary the provisions contained in a document. See section 128 sub 1 of the Evidence Act 2011 on the issue. See also the cases of Skybank PLC versus Akipelu Nwabueze versus Bauer, citation supplied. The facts that I had found settled and established as between the parties as enumerated as follows. 1, that in the year 2007, the claimants were variously given new and distinct contracts of employment by the defendants on different dates. See letters of appointment, exhibits CA1 to CA24, letters of confirmation of appointment, exhibits CB1 to CB15, staff identity cards, exhibit CC1 to CC24, pay slips, exhibit CD1 to CD20, and staff or conditions of service of the defendants 2004 and 2007, exhibits CE1 and CE2. 2, that in November and December 2010, the claimants received payments to their various bank accounts from the defendants. See bank statements of accounts of the claimants with Access/Diamond Bank, Keystone Bank, and FCM's bid, namely Exhibit DA to DA23, Exhibit DB, Exhibit DC to DC12, Exhibit DD, Exhibit DE, respectively, and the memo of the defendants on payment schedule of 1 month in lieu of salary of notice, Exhibit DH. 3, that a trade dispute between the Steel and Engineering Workers Union, 7, and the defendants was referred to the Industrial Arbitration Panel in trade dispute number IAP/HB/5839/11. See letters of defendant staff on deduction of salaries of union dues Exhibit CG1 to CG8, letter of appointment of a conciliator dated the 24th of March 2011, Exhibit CF1, and notice of award dated 17th of November 2011, Exhibit CF2. 4, that in objection to the award of IAP, an appeal was filed at National Industrial Court in appeal suit number NIC/ABJ/106/2011, and that the terms of settlements filed by the parties was made consent judgment by the court. See terms of settlement of parties and record of proceedings of 8th of April 2014 in appeal suit number NIC/ABJ/106/2011 as in Exhibit CH and Exhibit CI respectively. That an appeal against the consent judgment was filed by the claimant, but the appeal was withdrawn. See notice of appeal at the Court of Appeal and the notice of withdrawal of appeal dated the 30th of May 2018 as Exhibit CJ/DL. Now, on the basis of the established facts as found from the totality of the evidence placed on record by either side, it is my view that the questions or issues that arise for determination in the suit in consideration of the claimant's claim before the court and without prejudice to the issues variously formulated by learned counsel in the respective written submissions are narrow and could be succinctly distilled as follows. 1, whether or not by the doctrine of extopel pares judicatum and or defense of statute bar raised by the defendants, this honorable court can exercise jurisdiction in this action. 2, whether or not the claimants have established by credible evidence their entitlements to the declaratory reliefs and other reliefs claimed in this action against the defendant in the suit. 3, whether the defendant's counterclaimant's claim are not liable to be dismissed. In determining these issues, I should also put on record that I had carefully considered and taken due benefit of the totality of the extensive arguments canvassed by learned counsel for the contending parties in their respective written submissions, and to which I shall endeavor to make specific reference as I consider needful in the course of this judgment. I shall proceed to determine all the issues together. Now, I should restate the age-long settled principle of law that the question of jurisdiction goes to the root, fiber, and foundation of a case, and thus must first and foremost be considered, as it forms the basis upon which a court can entertain a suit. Jurisdiction gives life or otherwise to a suit. When it is raised at any stage of trial, the court will have to determine whether the subject matter is within its adjudicatory power. See NURTW and another versus Rec RTEAN 2012 Law Perfidion Law Report 7840, Humbaz Motel versus Boemer Bank PLC 2013 LPELR 20736, and Yahoo versus Ogunlewe 2014 LPELR 22184. I had considered the totality of the arguments canvassed by learned counsel for the defendants on the issue of estoppel parem judicata, aimed at stopping the claimants for relitigating in the instant case, together with the claimants' learned counsel's arguments in a position in which the correct legal principles have been adequately canvassed. The crux of the case of the claimants is that upon a dispute that arose between Steel and Engineering Workers Union of Nigeria, SEWUN, and the defendant, they were locked out of the defendant's premises on the 25th of November, 2010, without terminating their appointments as stipulated by the terms of their employment. The claimants alleged that in spite of being locked out, they still reported for duties at the defendant from the date of the lockout until the present case was instituted in 2017. The claimants further alleged that the defendants breached the procedure stipulated in the defendant's condition of service by not properly terminating their appointment, and also alleged that the action of the defendants had caused them untold hardship and embarrassment. The submission of learned counsel for the defendants is that the consent judgment made on the 9th of April 2014 pursuant to the trade dispute in the IAP and the appeal at the National Industrial Court between Peugeot Automobile Nigeria Limited versus Steel and Engineering Workers Union of Nigeria had conclusively disposed the claimant's case, and the court lacks the jurisdiction to entertain the suit. In other words, the contention of the defendants is that the claimants are stopped from litigating the same matter already determined by a court of competent jurisdiction. Learned counsel submitted further that the law allows the claimants as the members of SEWUN to sue their union through their union, that a trade dispute between the parties was submitted at the AIP, that the claimant's cause of action and claims are in tandem with the cause of action submitted at the trade disputes at the AIP and at the subsequent appeal at the National Industrial Court, which had determined by the consent judgment of the court. Learned counsel submitted further that the claimants cannot be allowed to come through the back door to litigate the same issues again by suing in their own names. Learned counsel finally urged the court to decline jurisdiction to entertain those suits, same having been caught up by the doctrine of estoppel pares judicatem. The cases of Silver versus INAC, Coal versus Gibona, Yanati Petroleum Chemical Limited versus EFCC, SSS and other versus NUT, citations also applied, were cited to buttress his submissions. In reaction, learned claimants counsel argued that the issue that was determined by the trade disputes at the IAP and on appeal by this honorable court was the lockout of the workers, and argued that the issue of termination of appointment of the claimants was never determined by the IAP. Learned counsel argued further that this court had ruled that the claimants are not parties to the appeal when they sought to be joined as interested parties, and as such, the claimants are not bound by the terms of settlement and the consent judgment in the National Industrial Court case, and thereby urged the court to hold that the doctrine of estoppel parem judicata is inapplicable to the instant case. Excuse me. As a starting point, it has been held, and rightly so, that an in-depth comparison of the doctrines of res judicata and abuse of court process revealed that both share similar preconditions for the applicability in terms of parties, subject matter, and issues. See Momo versus Adedoyin in 2017, Law Pavilion Electronic Law Report 43124. That being so, it is apparent that a finding that a suit is caught by the doctrine of estupel parem judicata automatically connotes or implies that the suit constitutes abuse of process of court. It is equally settled that as a general rule, once one or more of any issues have been distinctly raised in a course of action and determined between the same parties or their privies in a court of competent jurisdiction, neither party, its privies, agents, servants, is allowed to reopen or litigate any such issues all over again. This is so because where a course of action or an abuse or an issue has been determined in a previous suit between the same parties or their privies, they are, as a matter of public policy and in the interest of the common good, that there should be an end to litigation, stopped from bringing a fresh action in any court in the same cause or issue already pronounced by a court of competent jurisdiction in the previous action. See the case of Ajiboye versus Ishola, the case of Agbaje versus INEC. Citations all supplied. Excuse me. Before the plea of res judicata can succeed, the propounder must satisfy the court of the presence of the following features. One, that the parties in the previous and the present actions are the same. Two, that the subject matter and the issues in the two actions are the same. And three, that the decision in the previous action must be final and by a court of competent jurisdiction. See the cases of Cardozo versus Daniel, Abiola and Sons Co. Limited versus 7-Up Bottling Company Limited, Esuwaye versus Bosheri. Citations all supplied. I had proceeded to apply the parameters set out in the foregoing to the case at hand. Learned Claimants Counsel had argued that the issue of termination or mass sack was not before IAP in the trade dispute and or the appeal to the National Industrial Court. I consider it pertinent at this juncture to make reference to the documents admitted in relation to the trade dispute at the IAP and the award therein, as well as the documents relating to the appeal and the consent judgment of this honorable court as conveyed in Exhibit CF2, CH, CI, and CJ/DL. With reference to Exhibit CF2, the notice of award 2, paragraph 3 states, and I quote, the panel notes that on the 26th of November 2010, workers were locked out as a result of their demand to be unionized, and 67 workers have since not been recalled. This act of the second party is in violation of Section 9(6) of the Labor Act, Cap 11, Laws of Federation of Nigeria, 2004. The second party is hereby ordered to recall the said affected workers. End of quote. Parties are not in contention that an appeal was submitted in this honorable court in suit number NICM/APJ/106/2011 against the award of IAP in Exhibit CF2, and the consent judgment was entered by the court. I make further reference to Exhibit CH, the terms of settlement and consent judgment, where it is stated in paragraph B thereof as follows, I quote, Peugeot Automobile Nigeria Limited, PAN, shall in full and final satisfaction of the entire claims of steel and engineering workers of Nigeria 7 and its member in the suit, inclusive of but not limited to check of dues, termination, re-engagement, and or benefits paid to 7, the term of 10 million naira only. The court further held as follows, I quote, "These terms of settlement shall, upon being entered as consent judgment in this appeal, conclusively resolve in finality the dispute claims between the parties, and both parties and union members in the suit are stopped from litigating same in any form." End of quote. The documentary evidence before the court is overwhelming and does not support the arguments of claimants' learned counsel that the issue of termination of claimants' appointment had not been settled by the court. It is glaring that from Exhibit CH, the issue of termination of the claimant's appointment was inclusive in the consent judgment and had been finally determined on appeal by this court, and I so hold. The further argument of learned counsel for claimants borders on the parties in disputes before the IAP and an appeal at the National Industrial Court. Learned Claimants Counsel's argument is that the application made by the claimants to be joined as interested parties in the appeal was refused by the court on the ground that the claimants are not parties to the suit. I should remark that the interpretation of the ruling of this honorable court on parties before the court by the Learned Claimants Counsel is not only misconceived, but an attempt to mislead the court. As clearly conveyed at page 3 of Exhibit C1, the argument of the extant Learned Defendants Counsel on the application of the parties seeking to be joined as interested parties, that is the claimants in the present suit, is that the applicants must follow due process by applying for leave to appeal. My view is that the record of the court also does not seem to support the submission of the claimants' Learned Counsel that the claimants are not parties to terms of settlement and the consent judgment. The relevant testimony of CW2 under cross-examination by the defendant's Learned Counsel is as follows, I quote, "I recall Steel and Engineering Workers of Nigeria. I am a member of the union. It is 7 that initiated an action on behalf of the workers locked out and whose employment were terminated." End of quote. His testimony, still under cross-examination, is that, I quote, "I attended the court sittings of IAP in 7 versus Penn. The matter thereafter was on appeal at NIC. The claimants were all at the IAP and affected by the decision of IAP. It is true, 7 entered into terms of settlement with Penn, which was entered as consent judgment." End of quote. Now, under Part A of 3rd Schedule of the Trade Unions Act, Cap 437 of the Laws of Federation of Nigeria, 7 is a registered and recognized trade union, and that by virtue of the act, it had acquired the right to sue and be sued on behalf of its members. This court has also over time recognized the right of unions to sue on behalf of their members. See, Nest Oil PLC versus Nupeng, 2012, 29, Nigerian Labor Law Report, Part 82 at 90. See also Article 10 of International Labour Convention, ILO Convention number 87 of 1948. I have also reviewed Exhibit CJ, the notice of appeal filed against the consent judgment. The claimants clearly demonstrated that the matter was initiated through their union on their behalf. Ground 1 of the appeal states as follows. I quote, the learned trial judge had in law in holding that the appellant was not a party to this case when ab initio they caused the institution of the case due to the injury to them. So paragraph A of the ground 1 states, the appellants caused this matter to be instituted initially through the union, the second respondent. B, the union had no grievance whatsoever against the first respondent, except the grievances of the appellants. C, the appellation 67, which had appeared first in the industrial arbitration panel through the appeal, whereas 67 appeared throughout the proceedings of the National Industrial Court, refer to the appellant, end of quote. In my opinion, the withdrawal of the notice of appeal on the 30th of May 2018, after the institution of the instant case, was to conceal the facts which had been disclosed in the notice of appeal on the parties before the court. Without having to go far, I am of the view that the learned counsel for the claimants erroneously submitted that the claimants are not parties in the previous suit filed by 7 on behalf of its members. I therefore consider the totality of the arguments canvassed by the claimants' learned counsel that the claimants are not parties to the terms of settlement and the consent judgment as misplaced and inconsequential to the determination of the suit. Without any much ado, I must hold that the parties who litigated in the previous suit on appeal in suit number NICN/ABJ/106/2011 are in substance the same as the parties in the present suit. The arguments of claimants' learned counsel that the claimants in the present case were not parties in the previous case cannot be tenable in the circumstances, and I so hold. I have again examined the consent judgments relied upon by the defendants for the defense of plea of res judicata. By a careful examination of the course of action and the reliefs claimed by the claimants in the present case, it is apparent that they are clearly encapsulated and subsumed as revealed in the portion of the consent judgment reproduced in the foregoing. A clear understanding of the judgment contained in Exhibit CH will review and establish, as correctly submitted by learned counsel for the defendants, that the issue of termination of appointments of the claimants was conclusively and completely decided to finality. I so further hold. The position of the law is that a plea of res judicata operates not only against the parties, but also against the jurisdiction of the court itself, and robs the court of its jurisdiction to entertain the same course of action on the same issues previously determined by a court of competent jurisdiction between the same parties. See Cardozo versus Daniel and others, supra. On the basis of the foregoing analysis, therefore, I must, and am hereby uphold the plea of estupel perem judicatum raised by the defendants in the defense to this instant action. And I hereby hold that the judgment of this honorable court as appellate court to the award of IAP, that is Exhibit CH, clearly constitutes res judicata to the suit at hand. The implication is that the instant action ought not have been commenced in this court as it constitutes a flagrant abuse of the judicial process of this court and are so old. On the issue of statute bar, learned counsel on either side are ad idem as to what constitutes a course of action. This had been adequately captured in the respective written addresses. Suffice it to restate the tried position of law, the way statute prescribes that an action must be filed in a court within a specific period. Such provisions of the law must be strictly complied with in order to avoid being caught up by the limitation under the law. See the case of Oba JARMO 2 versus SK Adekoye and others, 2004, 19 Nigeria Weekly Law Report, part 891 at page 572. Learned counsel for the defendant submitted that the course of action arose on the 30th of November 2010, when the claimant's appointments were terminated, that the claimant's claim before the court is founded on the contracts of employment, that by Section 18 of the Kaduna State Limitation of Action Laws of Kaduna State, Cap 89, the claimant ought to have commenced the action within 5 years, but did not do so until 14th of February 2017, after the time allowed by law had elapsed, and therefore the suit as statute barred, thus robbing the courts of the requisite jurisdiction to entertain the suit. Learned counsel cited the cases of Asabaro versus Pan Ocean Oil Company Nigeria Limited, the case of Sifax Nigeria Limited versus Mbofo Nigeria Limited, citation supplied in support of a submission. Learned claimant's counsel argument on the issue of the action being statute barred is that the defendant resorted to self-help by locking the claimants out of its premises on the 25th of November, which is in breach of the terms and conditions of their service with the defendant on termination of their appointment. Learned counsel argued that the act being complained by the claimants is a continuous action and not statute barred. The cases of Fakwade versus OAU, or Rio and others versus Ocean and others, citations supplied were cited in support of his propositions. As correctly submitted by learned counsel for the defendants in his reply on points of law, unlike the Public Officers Protection Act, the defense of continuance of damage or injury is not available or an exception to the limitation of action laws, such as limitation law of Kaduna State. Therefore, the defendants not being public officer, the defense of continuance of damage or injury as muted by learned counsel is not applicable in this case. I should also remark that the recent decision of the Apex Courts in the case of National Revenue Mobilization Allocation in Fiscal Commission and 2 others versus Jibola Johnson and 10 others, 2019, 2 Nigeria Weekly Law Report, part 1656 at page 247 at 270, where the Apex Court held that POPA is inapplicable to employment contracts, is not relevant in the instant case. It is right. The statute of limitation is a law that bears claims after a specific period. It establishes a time limit for suing in a civil case based on the date the claim is accrued. The purpose of such statute is to require diligent prosecution of non-claims, thereby providing finality and predicability in legal affairs, like equitable doctrine of laches, statutes of limitation in their conclusive effects are designed to promote justice by preventing surprises through the revival of claims that had been allowed to slumber. See Fabi JSC in Soulgrave Holdings Incorporated and others, versus FGN and others, 2012, Law Pavilion Electronic Reports at 15520. In the present case, the defendants have heard that the completed act was on the 30th of November 2010, which right to sue the defendants expired and abated 5 years after, in 2015. The case of Nanji and others versus Iweke 2018, Law Pavilion Electronic Law Reports at 44043, the court held the view that the board, I quote, shall not, end of quote, is a mandatory provision which indicates that the action cannot be maintained or cannot take off unless brought within the stipulated time. Arising from the foregoing, therefore, I cannot help but agree entirely with learned defendants' counsel on the fact that the claimant's course of action is statute bad, having been instituted 2 years after the statutory 5 years. And I so hold. On that note, I resolve issue 1 as set in the foregoing against the claimants. Ordinarily, this judgment ought to have terminated at this point. However, I shall proceed just in the event that this court is held to be wrong to have upheld the plea of res judicata against the instant action, or that the action is not statute bad, to consider the merits of the suit by evaluating the evidence adduced at the trial by the respective parties. By reliefs 1 and 2 of their action, the claimants prayed for declaratory reliefs. The implication being that the burden for them to prove the allegation leveled against the defendant exceeds the regular burden provided in sections 131 and 132 of the Evidence Act 2011. The settled position of the law from time immemorial is that even though the power to make a binding declaration of rights is declaratory in nature, a court will only grant declaratory relief sought in an action principally on the basis of evidence adduced by the claimant without recourse to the evidence called by the defendant. The burden of the proof on the claimants in establishing a declaratory relief to the satisfaction of the court is somewhat heavy, in the sense that such relief is not granted even on admission of the defendants, as the claimants must lead credible evidence in proof of the declaration of rights is seeks from the court. See the cases of Dumas Nigeria Limited versus Urakoba, Ogolo versus Ogolo, Olabanji versus Omakwen, citation supplied. The facts asserted by the claimants which respects their claim for the breach of the conditions of their service with the defendants as captured in the witness deposition of CW1 and CW2 briefly stated is that the allegation that they were locked out by the defendants on the 25th of November 2010 without having their appointments lawfully terminated. The claimants further alleged that money paid by the defendants in their various bank accounts after the lockout was for December 2010 salary. The claimants further alleged that after the lockout, they had reported for duties until the instant case was instituted. However, the defendant maintained in its defense that the appointment of the claimants was validly terminated by the issuance of letters of termination of appointment, and that the payment that was made to the various bank accounts of the claimants in December 2020 was for the requisite 1 month's salary in lieu of notice and not for December salary as alleged by the claimants. The statements of accounts of the claimants with Access/Diamond Bank, Keystone Bank, and FCMB were respectively admitted in evidence as exhibits DA to DA23, DC to DC12, and DE, whilst exhibit DH is the internal memo of the defendants for the payment of 1 month's salary in lieu of notice. The defendants have heard that the claimants were issued their letters terminating their appointment, but that they refused to acknowledge the copies of the letters that some of the claimants later, at various occasions and for various reasons, requested for their letters of termination of appointment. The acknowledged copies of letters of termination of appointment are exhibits DG1 to DG15, also admitted as exhibits DIA to DIB, DJA to DJD, DKA to DKB are the requests made by some of the claimants for conversion of termination of appointment and letters of introduction. Some of the said claimants who had acknowledged the letters of termination of appointment are the 28th claimant in exhibits DG1, the 29th claimant in exhibit DG2, the 33rd claimant in exhibit DG3. The defendants also categorically denied that the claimants reported for duty after the appointments were terminated, since the appointments were lawfully terminated by the requisite payment of 1 month's salary in lieu of notice, and thereby refuted being liable to the claimants for their claims. Now, the said law, as rightly submitted by learned counsel for the claimants, is that a court will determine the terms of a contract and the rights of the parties from the agreements made by parties, which is binding on both parties thereto. It is equally right that in a master and servant relationship, in which the relationship is purely contractual, as the instant case, once there is purported termination of employment, the court will rarely make an order that it still subsists. This is on the principle that the court cannot force a servant on an unwilling master. However, a termination of employment by the employer will be wrongful if it is in the breach of the terms of and conditions of the contract. See the cases of Texas Nigeria PLC versus Kende, Oshisoya versus AfriBank Nigeria PLC, Obanye versus UBN, citation supplied. It is also settled that the initial burden of proving a breach of terms and conditions of employment is on the claimant. The terms and conditions of service in the staff handbook, exhibits E2, operative in 2007, at page 15 thereof states, I quote, "The company or the employee may terminate the appointment without assigning any reason whatsoever by giving notice or pay in lieu of such notice as provided for senior/junior staff 1 month notice or 1 month's basic salary in lieu." End of quote. Now, sections 131 and 133 of the Evidence Act 2011 stipulates that the claimants has the duty to lead evidence first in civil cases. Section 136 of the Evidence Act, Supra, provides that the burden of proof as to any particular fact lies on that person who wishes the courts to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. The burden may, in the course of a case, be shifted from one side to the other. These provisions of the Evidence Act have been considered by the courts in a plethora of authorities. See Onovo versus Mba, Ntuama versus Akpel Ime, Ezemba versus Ibeneme, and another citation supplied. It is clear from the above authorities and the plethora of cases on burden of proof that in order to discover where the burden of proof lies in a civil case, the court has a duty to peruse the entire pleadings of both parties. It is also the consensus of the case authority that in civil cases, the burden of proof initially lies on the claimant. In other words, in civil cases, the claimant has the initial burden to lead evidence to prove his assertion, but the burden of proof is not static. Once the claimant establishes a prima facie case, the burden of leading evidence in rebuttal shifts on the defendant and vice versa. I have considered the oral and documentary evidence by contending parties. In justifying the termination of claimant's appointment, the defendant acted on the employee handbook, Exhibit CE2, by which it is empowered to terminate the appointment without assigning any reason whatsoever by giving notice or paying lieu of such notice. The burden has therefore shifted to the defendants to prove that notice or payment in lieu of notice was given to the claimant as stipulated in Exhibit C2. The unequivocal finding of this court is that the defendant has essentially established by placing in evidence the claimant's bank statements at Access/Diamond Bank, Keystone Bank, and FCMB respectively in exhibits DA to DA23, DC to DC12 in DE, that it complied with the procedure as stated in Exhibit C2 by paying 1 month's notice, 1 month's salary in lieu of notice to the various bank accounts of the claimants in December 2010. On the basis of the foregoing analysis, I must hold that the claimants have failed to adduce any shred of evidence whatsoever to sustain or substantiate the alleged breach of terms of condition and conditions of the service against the defendant. In the circumstances, the claimants having failed to adduce any evidence whatsoever to support the claim for their respective claims for salaries and allowances and other entitlements as claimed, it will be needless to proceed to consider the claimant's other reliefs for damages and costs since the main claims have failed. The judgment of the court, the final analysis, is that whichever way the case of the claimants is viewed, whether on the ground of defense of res judicata or statute bar validly raised by the defendant and sustained by the court, or on the merits of the substance of the claim, which is bereft of any cogent evidence whatsoever, the suit must fail. Accordingly, the suit shall be and is hereby dismissed.
As the court pleases.
Now, the counterclaim. Has the defendant discharged the burden of proving its entitlements as claimed? There is no doubt that a counterclaim is a separate and distinct claim from the main claim. This is because Even if the main claim fails or is withdrawn or struck out, the counterclaim will survive. To put it differently, the same standard of proof required to prove the main claim is also required to prove excuse me, I'll take it again. This is so because even if the main claim fails or is withdrawn or struck out, the counterclaim will survive. To put it differently, the same standard of proof required to prove the main claim is also required to prove the counterclaim. See the cases of Attorney General of Lagos State versus the Attorney General of the Federation, Ogolioko Memorial Firms Limited and another versus Nigeria Agricultural and Cooperative Bank Limited and another. Citation supplied. The defendant's claims as special damages from the claimant, a sum of 8,075,000 being solicitor's fees for prosecuting the suit. In view of the in proof of the claims, the DW1 testified as the sole witness on behalf of defendants. The testimony of the DW1 is that the claimant's case is frivolous and vexatious, as the claimants had earlier pursued the extant claim through their union, and that the defendants incurred and paid the sum as professional fees directly resulting from the extant suit filed by the claimants. The receipt of payments of professional fees is tendered as Exhibit DM. The claimant's averment in defense of the counterclaim is that the defendants resorted to self-help, causing the claimants to institute the action, and that the defendant is not entitled to the counterclaim. The pertinent question is whether this relief can be granted. Mwaji versus Coastal Services Limited, 2004, 36, Weekly Report of Nigeria. It was held that it was improper, unethical, and an affront to public policy to have a litigant pass the burden of cost of an action, including a solicitor's fees, to his opponent in the suit. Therefore, I think that on the correct state of law, the claim for legal fees for representing the counterclaimant's action and for defending the claim does not form part of the action that can be granted. Without further ado, defendant's counterclaim fails in its entirety, and I so hold. In the final analysis, the claimant's claim, the defendant's counterclaim lack merit and substance and are hereby accordingly dismissed. Parties shall bear their respective costs. This is the judgment of the court. The judgment will be available by close of day or by Wednesday. Because of the peculiar situation, the court is not on site. I will have to pass it to them, scan it to them, sign it to them. So you might obtain it as from Wednesday, by God's grace.
You do respect my Lord.
Yes.
We appreciate the judgment of how much of this.
We're also much grateful to my Lord for the industry displayed in writing this judgment and delivering it within the shortest time. We are so grateful to my Lord. And in all honesty, my Lord, this is one of the most industrial judgment I've had in recent times. We commend my Lord for the industry displayed in writing this judgment within this short time. And we pray that our Lord will grow in strength and in wisdom. Thank you so much, my Lord.
Thank you very much, sirs. Thank you. Yeah, thank you. The court will rise. I think another meeting is being scheduled by another court, so I have to rise immediately. Thank you. Bye.
For 13 days.